Welcome back to another episode of our podcast. My name is David Levine, founder and CEO of ResTech Solutions. And today we are talking about protecting innovation in a digital first world with IP, confidentiality, and data risk for modern law firms. And I'd like to welcome today's guest, Brenda. And Brenda, if you'd like to take a moment and introduce yourself.
Sure. Thank you, David. My name is Brenda Schamy. I am one of the founding partners at DiSchino Schamy, a business and intellectual property law firm specializing in what we call the lifestyle industries. That's entertainment, sports, media, tech, hospitality, art, fashion, events, food, beverage, and so forth.
All right, sounds great. Glad you're able to join us today.
Thank you for having me.
So, yeah, let me just jump right in. So, we know today law firms are handling more digital assets than ever, from intellectual property, confidential data to proprietary client information. So, from your perspective, what are the biggest risks law firms face when protecting innovation in a digital first world?
Sure. Are you asking in respect to for the client's point of view or for the law firm's point of view?
I would say both, since I know law firms typically you have your own internal IP as well as, especially with what you do, you have a lot of sensitive data in IP for clients as well.
Sure. I think for clients, which I'm assuming is the majority of the listeners here, there's such a wide array of protections, which are maybe some more commonly known than others. But I also think that what a lot of people don't think about is the strategy behind some of the protections, right? Sometimes intentionally not filing something because it is public record, sometimes filing something under a specific IP company so that it is more protected and they can't tie it back to who it is that's filing these things. Sometimes intentionally not filing something, but having things in place like trade secrets policies or confidentiality agreements, I think is incredibly important. And then I think understanding how those documents work, right? Because a non disclosure agreement without the proper things in place behind it is only worth the piece of paper it's written on.
Great. Well, I appreciate that insight. And I know you've said you work with clients across tech, entertainment, hospitality, and a lot of other fast moving industries. So, what are some of the most common mistakes you see businesses make when it comes to protecting their intellectual property early on?
Sure. I think the last thing you said is the most important part early on. I think a lot of times people believe that they either can't afford it or it's not worth the expense early on to own some of the IP, the most common being, for example, their trademarks. And they will spend a lot of money developing a brand around a, a trademark that they don't own, only to come to find out 8, 10, 12, 15 months later that they can't own it or that it's incredibly expensive to fight to own it. So, I always say my dad used to tell me being cheap is expensive. And this is one of those scenarios. Trademark filings take anywhere from 8 to 10 months before you even get an initial response from the USPTO, which means that what you don't want to do is be so far in developing a brand to the general public and then either have to spend a lot of money to defend or to fight against owning it, or decide that it's cost prohibitive, even though you just spent so much money in marketing. The same goes for patents, the same goes for copyrights, et cetera, et cetera. So I think it's incredibly important that you very, very early on register what you can and work strategically with an attorney, ideally, in understanding what is worth registering, what is not worth registering, and how far in advance you need to do it, right? So I always say the best time to contact an attorney is right when you have the idea.
And just as a quick follow up, what would you say to businesses that are now hearing this the first time and realizing, okay, maybe I should have done something? Would you say, okay, you follow the same steps, or if a business is further along on the journey, what should they do if they've not done anything in this area?
Sorry, one more time, you got cut off right at the end.
So I was just asking, so what would you say to a business that's maybe further along in their path, but they just haven't done anything in this area? Maybe should they do first, or would it be the same as that early on business, just start doing what you can?
I think, yes, obviously, as soon as you can do it. However, not every business needs all the same type of IP protection, right? There are some businesses, for example, that are developing intellectual property, but actually don't care that much about the public facing brand of their own thing, right? So, for example, let's say you're developing software that is going to be white labeled for different companies, et cetera. And you're not really worried about building a brand around what you're building, but rather you're interested in protecting the actual software you're developing. The protection there would be different than somebody who's developing a public facing product that they want to make sure they own the name because they're building goodwill in that, right?
All right, makes sense. I appreciate that clarification. All right. And so we've talked about a few things, but but how has technology, especially the cloud tools, collaboration platforms, or remote work, changed the way you advise clients on confidentiality and IP protection?
Absolutely. So first is, the age old rule that nothing dies on the internet, and be aware of that. The second is that while a lot of these AI tools, for example, are incredibly useful when used properly, nothing there is confidential. And so be very aware of how, what, and when you say things. And I think in general, right, collaboration is incredible. We're all for it, but owning your IP before you walk into a collaboration is fundamentally important. And just be aware of anything from the fact that anything can be recorded, and again, in some states that's legal, in some states that's illegal, but you don't always know. And sometimes you may not be recorded, but there might be somebody else in the room, right? Considerations that we didn't have to worry about when we were all in person. So, I mean, there's such a wide array of different things to consider. And I think it's just a matter of being aware and acting accordingly.
All right. Perfect. And when you're helping clients turn ideas into protected assets, how important is coordination between legal strategy and the underlying technology being used to store and share that information?
I mean, I think in general, the best type of client attorney relationship is a collaborative one. The more the lawyer understands about what you're doing, where it lives, how it's moving around, who's interacting with it, the much more accurate and specific advice your lawyer can give you, right? We're very big at our firm of taking a very team approach to how we move and do things. What that means is also this idea of like, hey, we're doing things this way. Oh, it's actually shifting to this, or oh, we're using this with these people or those. And that changes the advice that I give a client, right? And so working together with your attorney, not only in how early you do things and the strategy of how to do things, but also as the product develops, shifts, works, and integrates with other people or other companies or other features is impossibly important.
All right. No, I appreciate that insight as well. Just even from my perspective, because it's something I've kind of thought about within the last year, because I actually got in realizing after the fact, it was more of, it wasn't like a true thing, but, someone trying to somehow solicit business really saying, oh, yeah, we were trying to file a trademark, but it looks like you already had this name for your business and we want to give you the opportunity, which actually brings me another question. Do people come to you and say they've gotten something like that, or what's your take when people receive those kind of emails? And I've gotten more than a few of those.
Yeah, those are absolutely solicitation emails. Be very wary anytime somebody's soliciting that way. Lawyers are actually not allowed to solicit business, so be very careful with those things. We can obviously, if you contact us, give you all the advice in the world, but we're not, and we can generally market, but we can't be, knocking on your door being like, hi, can I do this for you? So with that said, be wary of anybody doing that. And there might be some truth to what they're saying, meaning there may be somebody that filed a registration. There may be somebody, your name may be worth registering. Very rarely is it a one-to-one where they happen to have a client that wants to have your mark. And even if that were the case, it would be a gross conflict of interest for them to come to you and be like, why don't you register it first? Right? That would obviously be problematic. So that particular instance is obviously not proper, not likely legitimate. But that's not to say that there isn't value in your mark and that those emails typically come when you have a mark that's probably worth protecting. But I feel that way about all marks. So anytime you have any sort of brand, you should absolutely protect it. It would be improper if their letter was true, because if I have a client that has the same name as you and I'm coming to you first and saying, do you want to register it before my client does? That is absolutely a conflict of interest with my client. So obviously, the letter is untrue. However, there is merit in the idea that any brand is worth protecting. And if they're finding you, it's likely through some sort of search, targeted search, that's bringing up these results. But again, I think all marks and any brand that is forward facing that has value is worth registering. I always tell my clients, if tomorrow you got a cease and desist and had to completely rebrand, would that affect your market? Would that affect your business? Would that affect you even emotionally? And if the answer is yes, then you should register your brand.
What do you enjoy most about your role as a founding partner and strategic advisor to your clients?
Love the use strategic advisor because I think that that's a key role to what we do that sometimes gets lost in the art of being an attorney. I think sometimes the role ends up feeling to certain attorneys like it's just draft a contract, send it out. And I think advising and strategy is a huge part of what we do at our firm. So I love that you use that term. I think my favorite part is it has two parts. Part number one is the team that we've built. I do believe that building a team is the hardest thing you'll ever do in a business. And the team that we've built is something I am abundantly proud of. And on the other side, I think that the thing that I enjoy the absolute most is really being a puzzle piece in the world that each of my clients are creating. And so my clients are absolute world changers in what they do. And that's in so many different industries, but to some extent, they all have a really big impact in the way things are moving. And I get to be one little bit of that puzzle piece and helping bring that to life. And that's incredibly exciting, right? And some of that is really creative, and some of that is very hyper technical, and some of it is strategic thinking. And all of that is really exciting to me, but it's getting to be a puzzle piece in something much bigger than what we do.
Great. And this next question is actually one of my favorite questions I love to ask every guest because it always can surface something very interesting and unique. But are there any initiatives or focus areas you're working on right now, whether it's AI, automation, or new service offerings that are changing how your firm thinks about data protection or confidentiality?
So, about data protection and confidentiality to some extent, I think one of the things that we have really started to emphasize for a lot of our clients is global protection of IP versus just domestic. That obviously does have a lot of implications in the way of confidentiality, in the way of how we share information, right? We have a network of attorneys all over the world that we are affiliated with to file trademarks in literally countries I didn't know existed until we started doing this, which is really exciting. I do think that because of the internet and the way we move about the world these days, everything is global or expanding into global reach. And so just protecting your mark in the US for a lot of businesses is no longer enough, right? And so we're super proud and excited to be able to expand that globally, but that also comes with a lot of potential confidentiality concerns, disclosure concerns, right? Because now what law are we operating under? Who has what obligations to hold confidentiality? What do we disclose? What do we not disclose? So I think that that's something that while it's super exciting to be able to really expand our clients' brands globally, it also comes with its own set of considerations in the way of disclosures, confidentiality, safety and protection in our client's brand, and what information is distributed. Because again, we may know the US law really well and we may have a ton of safeguards in place here, but working together with local counsel, which we do often globally, also requires making sure that we're very strategic about what we disclose, how we disclose it, and what safeguards we can put in place when we do that for our clients.
All right. Well, great. And kind of as a follow up a little bit. So when you think about your own firm or your clients, how confident do you feel that the technical safeguards behind the confidentiality agreements and IP protections are actually holding up in practice?
I think it's always a moving target. And what I mean by that is, technology continues to move 100 million times faster than the law does. And that has always been the case. The law is just always behind. One of the things that I think our practice does really well is I come from a litigation background. I was a criminal defense attorney at the beginning of my career. What that allows me to do is really think in litigation terms when I'm drafting. And so a lot of times we are anticipating as much as we possibly can all of the gray area, all of the what ifs, all of the ambiguities before they come up. Um, if you have enough of that, then it helps with protection. That doesn't mean you can't get sued. That doesn't mean that somebody can't violate these things. It's just about how much you can then enforce, stop, do injunctions, whatever the case may be. But I think it's a matter of both keeping up with all of the new advances and at the same time drafting in a way of anticipating litigation from the onset.
That's some great insight as well. I appreciate that. And as we're kind of approaching the end of our segment here, are there any additional insights or final thoughts you'd like to leave with the audience?
I think, obviously as an attorney, I'm biased, but I think having an attorney on your team is fundamentally important, but specifically any time that you are in this intellectual property world, which is ambiguous, it's wide, it's interesting, and it's very strategy based. So find an attorney you trust, find an attorney that you can have real conversations with, and don't limit how much you explain about your business to your attorney. I can't tell you how often somebody will just mention something as a pass by comment and it'll actually be something that unlocks a huge part of their, assets that we can register or that we want to protect. So really have an attorney on your team that you feel is part of your team, right? Disclose as much as you can to them. Obviously, it's confidential by law, so that makes it really easy. But let's go back to the time where your attorney was your confidant, where your attorney was a partner in developing your business, because that's what they should be. They should be advisors. They should be helping you with strategy. And if you do that and you do that well with an attorney that really understands protection of both confidentiality of intellectual property, even of corporate structuring, which is, also part of what we do, there's so much value in doing that, right? There are times where I've seen companies not even fulfill their full potential, but have so much ownership in the way of their intellectual property that they were able to sell or exit or merge in a way that was far more beneficial because they had that ownership.
All right. Well, thank you so much for all those insights. I personally found this very interesting and insightful, mostly because of what I mentioned earlier. I have, kind of has things come up that really made me think about this and start to explore this avenue, which I realize even more now. Okay, we probably should be more serious about doing something. But I hope the audience, someone out there feels the same way. Because again, I'm sure there's a lot of people that are in a similar boat. So once again, thank you so much. And for anyone who would like more information, all of the information you can reach out to Brenda and her team will be in the description below this video. So Brenda, again, thank you so much.
Thank you so much for having me. Have an awesome day.
All right, you too.